So this video podcast is on some key end of session legislative process items. It's not an exhaustive list by any means, but these are some of the frequently asked questions towards the end of the California legislative session. The first one is the 72-hour in print rule. Basically, a bill cannot be passed or become a statute unless that bill and any amendments to it have been in print and published on the internet for at least 72 hours before the vote, unless the governor has basically issued a proclamation that it's needed to address a state of emergency. Consent calendar, be aware that there are different rules between the Senate and the Assembly regarding when a measure qualifies for the consent calendar. For example, Senate Rule 28.3A says that if a Senate bill or Assembly bill is amended in the Senate to create a new bill or rewrite the bill, then a standing committee cannot place the bill on its consent calendar. Note that the Senate also has a special consent calendar, and sometimes the Assembly utilizes what it calls batching to be similar to a special consent calendar. That's to be distinguished from the regular consent calendar. And then, of course, there's a first day consent calendar, which means it sits there for at least a day and goes over to the second day. And then the second day consent calendar, it's the second day consent calendar items that are eligible to be taken up that day. Both houses have what they call an inactive file, and bills taken off the Senate inactive file are returned to the second reading file. In the Assembly, however, bills that were on third reading that got moved to the inactive file are subject to a one-day notice for removal from the inactive file, but they are returned to the third reading file. So the Senate, when it takes a bill off inactive, puts it on second reading, and then the next day can go to third reading. The Assembly, however, moves it back to third reading instead of second. Session going back past midnight on the final day. Some people use the term stopping the clock. However, there's no provision in California law to stop the clock. Basically, during the second year, the even numbered year, the state constitution specifies only 5 types of bills that can be passed after September 1, which effectively makes August 31 at midnight the de facto deadline for the second year of the 2-year session. In the first year, it is simply a joint rule that may or may not be suspended in order to consider bills past that scheduled deadline, but there is no stopping the clock. Policy committee hearings during the last 2 weeks of session. With a rule waiver, committees can meet during this time period. For example, under Senate Rule 29.10 and Assembly Rule 77.2, bills that have been substantially amended in the other house have to be referred back to the policy committee. And those policy committee hearings are not subject to the prohibition on meeting during the last 2 weeks of session. Note the 2910 designation is done by the Senate Rules Committee, while Assembly Rule 77.2 is done at the discretion of the Speaker. One other thing to be aware of, the distinction between double jointing and contingent enactment amendments. There is a definite difference between these 2 types of amendments. Contingent enactment means that the bill or section of the bill is only operative upon, for example, a budget appropriation or even the enactment of another measure, another bill or a constitutional amendment to be passed by the voters. Double jointing amendments are amendments to address the issue of chaptering out. So when 2 or more bills propose to amend the same code section, they need double jointing amendments to ensure the provisions of both bills go into effect. Again, this is not an exhaustive list, but these are some of the most commonly asked questions related to the end of session processes.